Michael Penzer versus Transportation Insurance Company.
Chief Justice, Justices of the Court, my name is Marc Wites from Wites and Capitan. I'm joined at Council's table by Stuart Davidson from the law firm of Coughlin Stoya, and it's an honor to appear here today on behalf of the appellant Michael Penzer. The issue presented to this Court on a certified question from the 11th Circuit Court of Appeals, although not having been directly addressed by a court in Florida, is by no means a novel issue. 11 courts, including federal circuit courts of appeal, a state Supreme Court, intermediary state appellate courts, and federal district courts from throughout the country, have examined identical provisions from insurance policies providing coverage for advertising offenses based on identical claims for violations of the Telephone Consumer Protection Act, for sending an unsolicited facsimile advertisement, and have found, in essence, answering the 11th Circuit certified question in the affirmative, that coverage should be afforded. And we ask this Court today to reach the same conclusion.
Is the argument with regard to this provision being an ISO standard clause and the commercialized approach to that as being very vast and broad, is that something that's part of this record? Is that properly before us? Is that a proper argument? Where does that fit in this case?
I'm not sure if I understand Your Honor's question, but
is it someplace within our record already been argued that this is an ISO form, that this is language drafted? Is that part of the argument?
Yes. I mean, to answer the question, yes, it is part of the record. The insurance policy is part of the record.
No,
yes.
The aspect that this is an ISO form policy.
Yes, I believe so. I believe it is part of the underlying record, Your Honor.
It is. And so then that's a proper argument for us to consider with regard to how ISO has projected this clause and what it's supposed to do in its broad effect.
Well, I think that the manner from which this Court, as well as when the 11th Circuit looked at how Georgia courts would look at this issue in the Hooters versus American Global case, is not how an ISO would put it forward. It's not how an insurance company would put it forward. It's how would the ordinary person on the street...
I take it you don't want to answer my question on whether this is an ISO form and whether we should even consider that.
I do believe that it's an ISO form. I do believe that it's something to consider, but I respectfully disagree that it's the point of view from which the Court should analyze the provision at issue to determine whether or not coverage should be afforded. That's my respectful disagreement with Your Honor. I think Florida law on this issue is very clear. We interpret insurance policies as would the ordinary person on the street. And when there's an ambiguity, it is construed in favor of coverage. In order for transportation to...
But now you must agree that this entire clause, when you look at not only the one sentence, but you look at the entire policy provision, A, B, C, right down through the list, that this is designed to cover situations under Florida law, for example, where individuals have taken material that may be personal to me and used it in their advertising or in some way violated my privacy. Isn't that a fair reading if you consider each one of those elements and where the sentence appears in that overall coverage approach?
I respectfully disagree, and here's why, Your Honor.
You can't see that there.
My answer is twofold. One, I'd like to explain why I disagree, and two, I'd like to explain why, even if that is a reasonable reading, it's one of several reasonable readings rendering the clause ambiguous. But let me go back to the first point, if I may. When you look at these four provisions within the section of the insurance policy at issue, there are four independent offenses for which coverage may be triggered under this policy. Not one of these four are dependent upon the other. Not one is modified by the other. And that is a key distinction between the position of the appellant and the position taken by transportation insurance. Your Honor, for example, if you look at provision A, which is immediately above the provision B at issue here today, transportation chose to write the following language: oral or written publication of material that slanders or libels a person or organization or disparages a person's or organization's goods, products, or services. They're purposefully choosing to define the content which would trigger coverage under that section of the policy. When you go to the next subdivision, the one at issue here, which is in no way dependent on the first, they left out all of those descriptive words. And interestingly enough, the Telephone Consumer Protection Act had been passed 13 years before, maybe 12 years, 1991 versus a 2003 policy, the one issued here. They could have chosen to exclude coverage for this claim, but they did not. Now, moving on to subsection B, it reads oral or written publication of material that violates a person's right of privacy. No language within that provision addresses the content. And when you go to C and D, these are, again, conduct-based offenses that are not related to the content of the material.
All of it is under the definition of what an advertising injury is?
Yes, Judge.
Well, just explain then, because A is a libel or slander, but how is that an advertising injury?
It could be an advertisement, the content of which...
Does it have to be? In other words, can it be, we just finished with all these last year false light claims. Is that within one or are these, or do they have to come from an advertisement?
I think that it has to arise from an advertisement.
All right,
and
so
I think
first of all, so this isn't, you've got to, so in answer to what Justice Lewis is asking, you've got to look at the whole context here, because this isn't just covering libel and slander, if somebody did it by means other than advertising. Correct?
Well, I think you do have to consider that it's an advertisement, and there's no dispute that the material at issue is an advertisement.
Okay, but still, in trying to understand how broad or narrow this is, it strikes me that is also important to how we look at whether B refers to a content-based injury or it is broader. Now, on B, the question I have is that are you saying that B both covers something that just is unwanted by the person, an unsolicited advertisement of any sort, like if I, get something in the mail and I didn't want it, would that be a violation of, is there even a cause of action for that?
Interesting question that was asked both by the district court and by the panel of the 11th Circuit. And one, arguably, there may very well be coverage for such a claim. But here...
Well, is there such a claim that even exists?
Well, whether or not a person could bring, for example, a claim for invasion of privacy based on the receipt of something in their mailbox might be a question for another day and might arguably be a valid claim for invasion of privacy and be covered under this policy. But first of all, the issue before the court is not whether an invasion of privacy claim is covered under this policy. It's whether or not a claim based on the Federal Telephone Consumer Protection Act is covered, which Congress has explicitly said in its legislative history, and many courts have found implicates a privacy interest. Next, to address your question about whether or not, as a hypothetical, and I believe that was the court's question, the receipt or the sending of an unsolicited mail piece might also give rise to a claim. I think there is a material difference, and it's that material difference that not only led Congress to pass the TCPA, but it's very interesting to note that our own state, the Florida legislature, passed an identical provision that gave the power gave the power to the Attorney General, which isn't provided in the TCPA, to bring the very same claim, presumably to protect the very same interest. But why is it different?
Well, let me ask you what you're claiming the right of privacy in this contract arises from.
Well, I think that the right of privacy arises from several bases. First, I think the right of privacy is certainly part of Florida's common law, which includes a right to be free from intrusion or seclusion. And this court, Judge Quince and Judge Pariente, in their concurrence in the Ginsburg opinion, made clear that the previous categories of invasion of privacy claims that had been delineated in the agency healthcare case were by no means intended to, and I'm quoting, definitively limit the potential situations that might give rise to a cause of action.
It's not your position that it's the federal statute that you're relying upon?
It is the federal statute that we rely upon, yes, but I do think that in reading the policy at issue, the court has to determine not whether or not the plaintiff has stated a claim for invasion of privacy, because we haven't alleged that claim. It's whether or not there is a valid cause of action, which there's no question that there is, and whether or not an ordinary person on the street would read this policy in this language to determine that it is an invasion of privacy. And the reason
the
that
valid cause of action you're talking about is the federal cause of action.
Yes, Judge.
And would that cover, I know that this was an unsolicited fax about telephone service or something, correct?
Yes, Judge.
Does it cover an email, an unsolicited email?
No, the Telephone Consumer Protection Act does not cover unsolicited emails. It covers phone calls, but this case is about unsolicited fax advertisements. And if I could, I wanted to finish answering Judge Pariente's question before I leave the rest of my time for a rebuttal. And that is that inside somebody's home, there is a reasonable expectation of privacy. Unlike something that goes to a mailbox, an unsolicited fax ad occupies somebody's phone line. It makes noise in their home. It uses their ink, it uses their machine, and it puts something into their dwelling that wasn't there before, where a person has a reasonable expectation of privacy. And it's our position and the position of the 11 courts that have directly addressed this issue, that is why an ordinary person on the street...
You really think, though, that but for the Telephone Consumer Protection Act, that there would be a freestanding common law cause of action for somebody sending a fax that they didn't, an advertising fax into their house?
I do believe, and I think that the distinction is that the Telephone Consumer Protection Act provides a statutory remedy for a person to bring this claim without having to prove actual damages. And perhaps the difference might be that in bringing a claim under the common law, somebody would have to prove actual damages. Congress, in determining that these unsolicited advertisements, whether they came by phone calls or by faxes, violated a person's right to privacy, enabled consumers, just like the Florida legislature enabled the Attorney General to bring a claim without having to establish actual damages, to have the incentive of a statutory remedy to advance their remedy because of their invasion of privacy.
What's your response to the argument that that violates a person's right of privacy, modifies material?
I think that...
One of the, which is, from a grammatical point of view, is correct. Material that violates a person's right of privacy.
We think that it is equally plausible to read that provision of the policy to modify the term publication of material. And I think that you have to go to a technical, legal reading, perhaps through a tort lens, to read the policy that way. And numerous courts have said...
Aren't they suggesting, if you do that you're really taking the words of material out of the sentence? What's your response to that?
I don't believe that, because I think that the clause at the end modifies the publication of material. And I think that the material here is the advertisement. And courts have ruled, we've cited them in our briefs, that you can't construct, in using a rule of statutory interpretation, read something to make it nonsensical or to eviscerate the purpose.
So it modifies not just the word publication, but publication of material, the phrase together? Is that what you're saying?
That's what I'm saying, but I'm saying something else in addition, which is that even if the court could read it the way you are suggesting, Justice, it could also be read the way that we are suggesting, which means at worst, there is an ambiguity here, which makes this provision susceptible to more than one reading, which renders an ambiguity. It has to be construed against the insurance company that chose not to define it in the way they wish to define it now in hindsight, and fine for coverage and answer the 11th Circuit's question in the affirmative. Thank you.
Okay.
May it please the Court, Raul Cantero for Transportation Insurance Company. I'd like to hold up the advertisement. I know it's hard to read from over there, but it is in the record. It's attached to the complaint and to the answer, and it's just a simple advertisement for free phone and accessories for Nextel. Sign up on Nextel's free incoming plans.
But that's not really the issue that's before us today, is it? Whether it's offensive, not offensive, really all what we need to do is to analyze this policy and that provision in the policy on however we do it to determine, you may win down the road or whatever on whether there is a cause of action, is not. But isn't that really what we're supposed to do today? And isn't that really the only issue we have?
Certainly. But
okay.
We have to look at the allegations in the complaint.
Right, but I mean, whether there's something that's offensive or is not or whatever is really not something we decide.
Absolutely.
Okay.
And the other part about that, though, I didn't know about this Telephone Consumer Protection Act, but
I didn't either, and apparently neither did Southeast Wireless.
And that's the whole. But I would assume the insurance industry knew about it because it came out 13 years before. And of all the kinds of things that somebody that does advertising would want to have protection against, wouldn't it be, I mean, that a innocuous ad, but going in this medium, being sent by fax, is going to give rise to damages. And for a standard insurance policy that's especially covering somebody who does advertising or might be in the advertising business, not to have coverage for that claim seems to be it would have to be a very specific oversight not to want to have coverage for it. So, in other words, I agree that looks innocuous. I can't believe that Congress has given all these damages or whatever, but it sounds like the kind of thing that you would want to have coverage for. And the question is, does B provide that hook?
Correct, Your Honor.
And is that what the insurance companies intended, that be the hook?
And I think that's what we have to look at the plain language of the policy. I think, as Justice Lewis was pointing out, and our argument is that if you look at the phrase in the context in which it stands, the phrase as a whole, in addition to looking at it in the context of the provision surrounding it, you can only reach one conclusion, and that is that it's designed to protect against secrecy-based invasions of the right to privacy.
Let's walk through a meaning of the language itself, where it says written publication would mean dissemination. So a written dissemination of facts, that's a material, that violates a person's right of privacy. Here they say the right of privacy comes from at least a federal statute. So from a plain meaning reading, why wouldn't, if you have a written dissemination of a fax that violates the federal statute, why isn't it covered?
Because, Your Honor, you have to look at the definition of right of privacy under the Florida common law and what that right of privacy entails.
If I look at right of privacy in plain meaning, it would seem to me to be any right given to someone, be it by federal or state law, common law, constitutional, statutory, any kind of legal right that they may have.
Well,
do you disagree with that?
Yes, Your Honor. We don't look at it that way. Under Ginsburg, this court looks at whether the common law provides a right of protects that particular right. The policy protects against offenses. This is a liability insurance policy that protects against certain offenses. Those offenses include, for example, libel, slander, material that violates a person's right to privacy. Those can only be interpreted according to the common law. They can only be defined. You can't look at libel and say, what is the plain meaning definition of libel? This court in Ginsburg said we need to look at the common law definitions, because if there's no right, there's no violation under the common law, then the policy doesn't cover it.
But now that was the sexual harassment
yes, Your Honor.
kind of case that we were dealing with there.
Correct.
Does that make a difference in what we look at as to how we interpret this?
The analysis doesn't make a difference, Your Honor, because what the court did, and you disagreed with what the court did, but the court looked at what the common law provided for, and if the common law did not protect that particular invasion of privacy, and the majority said the common law invasion of privacy doesn't include sexual harassment,
Well, which I would agree with as a
You
common
agreed
law.
with that
Yeah,
part.
Yeah.
But the court said we then stop there, because if the common law doesn't protect it, then it's not covered under the policy. And this court said, and 6 justices agreed with that it renders the other questions moot, because by definition there's no coverage. And that's why I think you need to look, to continue answering Justice Polston's question, you need to look, when you look at right of privacy, what is protected under Florida law under that right of privacy? And not even the plaintiffs claim that the right of privacy under the Florida common law protects this kind of conduct.
They're also saying it's coming from the federal statute. Where is the limitation just to Florida common law? Why wouldn't you read that provision and say this right of privacy comes from any legal right that you may have?
Because the right of privacy is a common law right of privacy, and it's interpreted. The policy is interpreted under Florida law.
But how about if there's a Florida statute, which there is, it's just it doesn't provide the citizens of the cause of action, I take it, but would this not come into play for the claims against by the Attorney General, if there are any civil claims?
No, Your Honor, because...
And why not?
Because the Florida law, common law right of privacy doesn't protect against those kinds of things.
But again, are you sure that that's what Ginsburg really stands for? That I mean, Ginsburg was really analyzing whether that sexual harassment was part of the traditional Florida common law privacy rights.
Yes.
Isn't that the main thrust of that?
But it's also, when you look at definitions in a policy, you look at the definitions under the common law definitions, because those are legal terms. When you're defining offenses under the policy, they're by definition legal terms. This policy protects against violations of a right to privacy, not violations of privacy.
What if Congress had expressly provided in this statute that's at issue here that it is a violation of the citizen's right to privacy to send these faxes? Would that make the analysis different?
No, Your Honor. But I am not saying that this policy doesn't cover any statutory offenses. Let me be clear about that. If there was a federal statute that prohibited putting in a fax advertisement somebody's picture without that person's permission, if you look at the facts of that complaint, it would state a cause of action for invasion of privacy under Florida law, regardless of whether the complaint alleges violation of right of privacy under Florida law. Even if it only alleges a violation of that federal statute, it would be covered because it would constitute a violation of privacy under Florida law.
Can I ask sort of a related question? But if you start with the coverages in this case, it applies to bodily injury, it applies to personal injury, and it applies to advertising injury. And it says advertising injury caused by an offense committed in the course of advertising your goods, products, or services. Now, if somebody was looking just at that and didn't to say, well, do I need a definition to understand what advertising injury is? But that would seem to me to be a very broad statement of coverage, which is that it's an offense in the course of advertising your goods, products, or services. So if I get sued for something that is in the course of advertising my goods, services, or products, I'm going to be covered if I'm in the business, and then you have to go to some other place and say, but if I'm in the business of advertising. So is that, and has that been, in terms of trying to look at the policy as a whole, if they're going to restrict what is meant by offenses that are in the course of advertising your goods, products, or services where you can be sued, doesn't that speak to having a broader than definition of what the advertising injury is? I mean, in other words, we don't need to know personal injury. We all know what that is. But that it is covering offenses committed in the course of advertising.
Your Honor, I think it doesn't cover all offenses, because then you have to look at subsections A, B, C, and D, which defines the type of offenses that are covered.
Well, what would not be, of those A, B, C, D, what would not be covered by advertising injury?
Sending an unsolicited fax transmission.
Other than that.
I think there are several things that aren't covered. You really have to look at what is covered.
But I'd like, let's think about what it is that, you said these are all secrecy-based types of claims, and infringement of a copyright isn't. I mean, that's and that's certainly both federal and federal law. Misappropriation of advertising ideas or style of doing business is not a secrecy-based.
Well, they're all content-based, Your Honor. It's all based on what is actually contained in the advertisement. As Justice Lewis pointed out, what is in this advertisement is irrelevant. There's nothing in the content of the advertisement that...
to the extent that...
Except that it's advertising.
It's advertising,
yes.
So the content is relevant to that extent. As
right.
a personal note,
but there's nothing in there that would violate someone's right to privacy.
But it
at
is
least.
relevant. But the Congress, in enacting the TCPA, found it to be an offense because it was infringing on a person's right of privacy.
I don't think that's what Congress said, Your Honor. And in fact, most faxes in this...
Were they worried that we were going to just use up our ink on our fax machines?
That was part of it. And the second is that it would infringe commerce because by sending fax advertisements that are unsolicited, you're preventing those businesses from sending their own faxes, number one, and from receiving faxes from other people. Remember, these are businesses. The right of privacy doesn't protect a business. A business has no right of privacy, so Congress could not have intended this to be protecting any business's right of privacy. It was supposed to promote commerce.
But is it limited in that way? I mean, when you read it, it doesn't seem to just limit it to commerce.
No, but it doesn't limit it to privacy. It doesn't talk about privacy. It just talks about sending an unsolicited...
But it seems to be open to all individuals as well as companies.
Yes.
Okay. And that we do have, it seems to me, some case law that says that privacy really is not only secrecy, but seclusion. And so how do we get around the fact that this kind of unsolicited fax really does interfere with someone's right of seclusion?
Because, Your Honor, in those cases that say it interferes, they look to their own state's common law. In fact, in the Hooters decision from the 11th Circuit, which was based on Georgia law, they specifically said that the Georgia common law of right to privacy arguably covers this kind of conduct. And so that's why we go back to Ginsburg, and you have to determine whether the Florida common law right of privacy would protect against this kind of conduct.
And that's why the question that a former justice used to ask to litigants and advocates was, where's the weight of the authority in this country on whether this particular provision covers violations of the TCPA?
Your Honor, it depends on how you look at it. I think it's pretty even if you understand, as I suggest, that the phrase making known in the context of this phrase means the same thing as publication of. There are cases that go the other way, no question.
I mean, aren't most of after the Seventh Circuit and I think it was Judge Easterbrook, after that, hasn't that view? I mean, and I guess that's...
There's Ace Mortgage Funding from Southern District of Indiana, which was after the Illinois Supreme Court's Valley Forge case that specifically adopted American states and rejected the reasoning of Valley Forge for Indiana law.
But I guess, and although we don't necessarily look to always to the weight of the authority, the fact that so many courts have interpreted this as at least being ambiguous in order to include the violation of a person's right to be left alone as well as the content, do you at least agree there, maybe you can't, I mean, is there, that there's an ambiguity in
No, I don't agree with that,
because
Your Honor.
Because you agree, though, if we find an ambiguity, then all of the different rules of insurance contract construction end up applying.
Correct. But if you recall, in this case decision, in this court's decision in Taurus Holdings, there was a split in the country about whether the term arising under in a policy was ambiguous. Some courts had said it was ambiguous, other courts said it was not. Despite that split, this court looked at it on its own and said, as a matter of Florida law, we hold that it's not ambiguous. So this court, it may factor into it, but that's not dispositive of whether this court believes that there's an ambiguity.
But isn't then in this state, and I realize that the right of privacy in the Constitution is a right to be left alone by government, but don't we have a history in this state of really protecting that right to be left alone?
Yes, Your Honor, but if the court were to read that right so expansively, it would have decided Ginsburg much differently than it decided. As a matter of the common law, it looks to what the common law protects, not what the Constitution protects. And there are some other distinguishing features I'd like to point out in the contrary cases, Your Honor, and that is that the vast majority of those cases, in fact, the vast majority of all cases on this issue, were duty to defend cases. And if you read those contrary cases, they specifically point out that under the law of those particular states, and this includes Valley Forge, for example, they say that where there is even potentially coverage within the policy, then there's a duty to defend. Other courts say where the allegations could arguably be covered under the policy, then there's a duty to defend. And some of those courts specifically refused to consider the indemnification issue because they were only considering at that point the duty to defend.
I understand. Let me move you. You're running out of time. I want
Yes, Your Honor.
two questions to you.
Certainly.
You're familiar with the antecedent rule.
Yes, Your Honor.
Is that a rule
I'm a fan.
of construction that applies only if there's an ambiguity, or is that a grammatical rule that applies in a plain meaning analysis?
It's a grammatical rule, Your Honor, because in order to determine an ambiguity, you really have to look at certain rules of how you read a provision. And this court, in other cases, has used those rules of construction to determine whether there's an ambiguity.
But here, go ahead. You need to add a couple more questions.
One more question.
Sure.
There are two exclusions. That's not certified by the 11th Circuit.
No.
That's not before us.
Correct.
Correct?
Correct.
Okay.
Yes.
Let's grammatically look at the sentence. Certainly the verb there is publication, isn't it?
Yes, Your Honor.
And the of material is a prepositional phrase that modifies publication, does it not?
Yes.
And the oral or written also, those are adverbs that modify the publication. So I'm having a difficult time that it's not publication that violates rather than material, because the material could be anywhere. It could be in your hand, could be all kinds of places, but publication is really what you're talking about, the act of publishing.
Because material, in the context of a sentence, material means information, content.
Well, it does. I don't disagree with that. It must be something.
It must be content.
But it is the publication that violates.
Right. But so far I agree with you, but now we have to look at the rest of the sentence.
That's what I'm doing.
Material that violates a person's right to privacy.
Well, I think it's a publication that violates. It's not necessarily the material. It is your act of invasion. It's the act of invasion because, as you said, the content makes no difference. It's the act of invading, and that is the publication. Is it not?
Yes, but I submit that it's the right to privacy then modifies material. That material that violates a person's right to privacy. So it's the material, not the publication, that has to violate the right to privacy.
But if you read it, publication that violates, then certainly it's covering that.
If you read out of material, then...
Well, no, you don't read it out. But if you say that publication that violates rather than of material, because of material being a prepositional phrase there, then there would be a question. I understand your argument. I mean, if I look at this as an overview, not thinking about this federal statute, I mean, it's pretty clear to me. This is, I mean, all these pertain to the same thing.
Yeah.
Yet I'm struggling with, somebody else. There's like 7 or 8 other courts and other people, intelligent, logical folks, say no, that could read differently.
Well, Your Honor,
and
because
so that creates an ambiguity that maybe needs construction.
First of all, most of those cases are duty to defend cases where they put on a different lens. Secondly, a lot of those courts have said this would be covered under the law of violation of privacy in our state. This would cover it, like Hooter said. Georgia law would cover this kind of conduct as a violation of the right to privacy.
But isn't the real question here is what a reasonable policyholder would understand or might reasonably understand from the language in the policy?
Not in defining the offenses under the policy. Otherwise, Ginsburg would have skipped the first question, which was whether there's a cause of action, and gone directly to the second question, which is it covered under the policy? Instead, Ginsburg said, since there's no cause of action, it's not covered. And before I sit down, I wanted to answer your first question, Justice Lewis, which is whether the ISO policy issue was in the record. It is not in the record. It was raised for the first time by United policyholders, and I don't believe it's appropriate for this court to consider that argument. Thank you very much for your time.
Rebuttal?
Yes, thank you, Chief Justice. I'd like to begin by addressing Judge Perriente's question, which was, where is the weight of the authority? With respect to Mr. Quintero, it's not even close to being even. It's not close to being a split. The overwhelming authority on this exact language and this exact claim under the Telephone Consumer Protection Act is for a finding of coverage.
But do you agree that there is a difference between a duty to defend case and a coverage case as far as what is looked at in terms of deciding duty to defend versus whether there's actually coverage? And is Mr. Quintero correct that there are many cases that are dealing with duty to defend?
First, yes, absolutely. Under Florida law, the duty to defend is broader than the duty to indemnify or to provide coverage. But no, I disagree with Mr. Quintero, who wants to read these questions and read these cases and say they're all duty to defend cases, which is not the case. And in fact, when you look at the cases upon which Mr. Quintero and Transportation Insurance Company want to rely, they're all talking about, one, different language, making known, which the 11th Circuit in the Hooters case and other courts have said, connotates and focuses on a secrecy issue not present in this language. Second, the cases that have found no coverage have all distinguished, they have not all, that's an overstatement, many of them have distinguished the Hooters case, which since it was issued, which came after the 7th Circuit Court of Appeals opinion.
About the Hooter case, Mr. Quintero contends that the Hooter case was decided the way it was decided because the Georgia, ostensibly, the Georgia common law on a right to privacy would cover this kind of situation, and he contrasts that as saying that the Florida common law right of privacy would not. And what is your response to that?
Several-fold, Your Honor. First, I don't believe Mr. Quintero was able to provide an answer because there is none, that the confines of Florida's law on invasion of privacy are so limited so as not to include this. Second, the 11th Circuit in the Penzer case that brought the certified question here, in rejecting and noting the infirmities of almost the entirety of the federal district court opinion that ultimately brought us to this court, said that Florida and Georgia laws that relate to the interpretation of insurance policies are similar. And what Transportation Insurance Company is essentially arguing is not just should this court ignore the federal statute, which they seem to want to rename now as a business protection statute. It's a consumer protection statute. Ignore that. Find that Florida law is so different from the common law of every state under which these claims have been brought and the laws that they've been brought, that no reasonable person could find that the coverage, that the policy here and the language here triggers both a duty to defend and a duty to provide indemnification and coverage.
Can you tell me if they had wanted to, in your view, limit it to content-based material that violates the right of privacy, how would these sentences be constructed?
Well, I have two answers for that question, Judge. The first, we actually have put both in our initial and our reply brief. They could have defined it, and they are now seeking to define it as oral or written publication of material, the content of which violates a person's right of privacy. They didn't do it. They chose not to do it. Second, we know that transportation knows how to define terms in an insurance policy and to define advertising injuries based on the content. How do we know that? We simply look at subdivision A of this policy, where they wrote oral or written publication of material, tracking the same language as B, that slanders or libels a person or organization or disparages a person's or organization's goods, products, or services. That is why there is it's clear they could have written it that way. They
what if
didn't.
They had in that same A and put or violates the person's right of privacy, would you agree then in that situation, if they hadn't put B in, that would only, in other words, left out B and just said, or violates a person's right of privacy? Would you agree then it would be limited to content-based?
Likely I would, because there wouldn't be a solely conduct-based provision under which coverage would be afforded under this policy.
It seems to me, as I think about it, that that would be since they're using disparaging as well as libel and slander, that would be the easier way to add it in, or violates the right of privacy, if they were simply going to content-based for A and not need B.
In retrospect, I'm sure they wish they had done that.
Well,
but
or maybe they
didn't.
want to cover. We don't know.
I think it's also important to touch on one other point that's been discussed and as at the heart of some of the questions asked by several of you today. It goes to this issue of, well, should we be looking at rules of statutory construction, or should we be looking how the ordinary person on the street would read this policy? Certainly Florida law says we look at how the ordinary person on the street would read the policy. But we can also look at the doctrine of the last antecedent, which they want to rely on to say that it defines only material and not publication. And I think we cite a case from the first DCA in our brief on page 7 of our reply brief, the Fortune Insurance Company versus Department of Insurance case, that I think is very instructive in talking about when the doctrine of the last antecedent does not apply. And with my 10 seconds left, I'll read it, or maybe 10 seconds over.
Yes.
When several words are followed by a clause which is applicable as much to the first and other words as to the last, the natural construction of the language demands that the clause be read as applicable to all. That is how the ordinary person would read this policy. That is why all of the courts, with the exception of the district court below, have found that coverage should be afforded here. And we respectfully request that this court answer the certified question from the 11th Circuit Court of Appeals in the affirmative. Thank you.
Thank you both for your arguments. The court will take its morning recess for 10 minutes.
Please rise.